Most Americans assume their citizenship is permanent, something that can never be taken away. But what if that assumption is wrong? In 2025 and 2026, the United States government has made citizenship revocation one of its top 5 enforcement priorities. Thousands of naturalized Americans are now being reviewed. Some have already lost their citizenship in federal court. But here's the critical question. Under what circumstances can the U.S. government actually strip someone of their citizenship? And can it happen to you? In this video, we break down every legal ground, from fraud to treason, and explain exactly how the denaturalization process works. Stay until the end, because the answer may surprise you. Before we dive into the grounds, let's define the term. Denaturalization is the formal revocation of U.S. citizenship that was previously granted through the naturalization process. It is not the same as renunciation, which is when a citizen voluntarily gives up their passport. Denaturalization is something the government initiates against you. And here's the most important legal point. Denaturalization only applies to naturalized citizens, people who immigrated to the United States and later became citizens through the legal process. It does not apply to people born on American soil, who hold citizenship by birthright under the 14th Amendment. If you were born in the United States, you cannot be denaturalized. That constitutional protection remains firm. For now. The legal authority for denaturalization comes from Title 8 of the United States Code, specifically Section 1451, part of the Immigration and Nationality Act. This law gives the Department of Justice the power to file a civil lawsuit in federal court to revoke a person's naturalization. There is also a criminal pathway under 18 U.S.C. Section 1425, where a conviction for naturalization fraud results in automatic revocation of citizenship. The government cannot revoke citizenship on its own. USCIS investigates and recommends revocation to the DOJ, where a federal lawsuit is then brought. In every case, the final decision must be made by a federal judge. No government agency can strip citizenship through an administrative order alone. A court must be involved. The first and most common ground for denaturalization is what's called illegal procurement of citizenship. This applies when a person did not actually meet the legal requirements for naturalization at the time citizenship was sought. For example, maybe they didn't satisfy the continuous residency requirement, which requires 5 years of lawful permanent residence, or perhaps they failed to meet the good moral character standard, a legal test that disqualifies people with certain criminal convictions. Crucially, illegal procurement applies even if the applicant had no fraudulent intent. If the individual simply did not qualify, citizenship can be revoked. No deception is required. Just being ineligible at the time, even unknowingly, can be enough for the government to pursue revocation years later. The second major ground is fraud, specifically, willful misrepresentation or concealment of a material fact during the naturalization process. The fraud must have occurred either orally during the naturalization interview or in writing during the application process. To prove it, the government must show 4 things. The individual misrepresented or concealed a fact, the misrepresentation was willful, the fact was material, and the person procured citizenship as a result of that misrepresentation or concealment. This could include hiding a prior criminal conviction, lying about immigration history, or concealing membership in a prohibited organization. The key word is willful. An honest mistake or a translation error is not the same as deliberate fraud. But if deception was intentional and influenced the outcome, denaturalization can follow. One of the most important legal protections for naturalized citizens is the materiality standard. It's not enough for the government to prove you made a false statement. They have to prove that the false statement actually mattered. The Supreme Court reinforced this in Maslanjak v. United States in 2017, which established that false statements made during the naturalization process must be shown to have influenced the naturalization decision in order to justify revocation of citizenship. In other words, if you made a minor mistake on a form that had no bearing on whether you qualified, that mistake alone cannot be used to denaturalize you. The government must prove its case by clear, unequivocal, and convincing evidence, a burden substantially identical to proof beyond a reasonable doubt. A third ground for denaturalization involves membership in subversive organizations. If someone concealed their affiliation with certain prohibited groups when applying for citizenship, that concealment can trigger revocation proceedings. Historically, this ground was used extensively in the post-World War II era against former Nazi war criminals who had lied about their wartime activities and entered the United States under false identities. The government ran a dedicated program, known as Operation Last Chance, that successfully denaturalized dozens of former Nazis living in America. Today, in June 2025, the Trump administration added to the existing list of priorities individuals who furthered activities of gangs or cartels, and individuals involved with human trafficking offenses. Hiding gang or cartel ties during naturalization is now an explicit priority target. Closely related to fraud is the specific issue of concealing a criminal history during the naturalization application. U.S. citizenship applicants are required to disclose arrests, charges, and convictions, even for offenses that occurred before they entered the United States. If an applicant deliberately hid a disqualifying criminal record, that concealment becomes the basis for denaturalization later, sometimes decades after citizenship was granted. The Justice Department's guidance identifies specific priority categories: individuals who concealed criminal histories during their naturalization process, those who committed financial fraud including PPP or Medicare fraud schemes, and gang members connected to drug cartels. The government is now actively digging through historical naturalization files to identify these cases using digital databases and law enforcement records that didn't exist when citizenship was granted. So how does the process actually work? It begins with USCIS, U.S. Citizenship and Immigration Services, which conducts investigations and reviews naturalization files. If USCIS believes sufficient evidence exists, it refers the case to the Department of Justice. If it believes sufficient evidence exists, the DOJ's U.S. Attorney's Office files a revocation of naturalization action in federal district court for civil cases or criminal charges for criminal cases. A federal agency cannot revoke citizenship on its own. The decision must be made by a federal judge after the person has been given the opportunity to respond. The individual facing denaturalization has the right to legal representation, the right to present evidence and witnesses, and the right to appeal any adverse ruling. This is not a fast or simple process. Civil denaturalization cases typically take years. Beyond the civil pathway, there is also a criminal route to denaturalization that can move more swiftly. If a person is convicted of naturalization fraud under 18 U.S.C. Section 1425, denaturalization is automatic under 8 U.S.C. Section 1451e. This means that a criminal conviction for lying during the naturalization process eliminates citizenship as a direct legal consequence. No separate civil lawsuit is needed. However, even under this criminal route, the Maslin-Jack standard still applies. The false statement must have been material to the citizenship decision. Federal prosecutors must prove the lie actually influenced the outcome. This criminal pathway is more aggressive and has been used in high-profile cases involving war criminals, national security threats, and individuals who committed serious crimes before becoming citizens. In 2025 and 2026, denaturalization went from a rarely used legal tool to a major government enforcement priority. On June 11, the Department of Justice issued a memo instructing federal prosecutors to prioritize and maximally pursue denaturalization proceedings in all cases permitted by law and supported by the evidence. The directive elevates citizenship revocation to one of the Civil Division's top 5 enforcement priorities. The new directive instructs USCIS to refer 100 to 200 cases per month to the Justice Department in fiscal year 2026, potentially reaching up to 2,400 cases annually. To put this in perspective, that's more than a 20-fold increase from historical averages. This represents the most aggressive denaturalization push in modern American history. To understand just how dramatic this escalation is, look at the historical numbers. From 1990 until 2017, the federal government opened an average of just 11 denaturalization cases per year. During the first Trump administration, this increased to 25 cases per year. The Biden administration filed only 24 cases during its entire 4-year tenure. In 2025 alone, 13 cases were filed and 8 were won. Now compare those figures to the potential 2,400 cases annually under the new directive. An unprecedented escalation in modern U.S. history. USCIS, is reallocating staff and deploying specialized experts across approximately 80 field offices to review past naturalization approvals. Whether these referral targets can realistically be met, given the legal burden required in federal court, remains a serious question. Despite the aggressive political push, the Constitution places firm limits on denaturalization. The landmark Supreme Court case to know is Afroyim v. Rusk from 1967. The Supreme Court held that citizenship is a constitutional right which Congress cannot take away, absent voluntary renunciation or fraud in procurement. Additionally, the Supreme Court has ruled that the government cannot strip someone of citizenship for conduct that occurs after naturalization, only for problems with how citizenship was originally obtained. In other words, if you became a citizen legitimately and later committed a serious crime, the government cannot denaturalize you for that post-citizenship crime. They can prosecute and imprison you, but your citizenship remains protected by the 14th Amendment and Supreme Court precedent. Separate from government-initiated denaturalization, both native-born and naturalized Americans can voluntarily lose their citizenship by committing what are called expatriating acts, defined under INA Section 349. A person shall lose their nationality by voluntarily performing these acts with the intention of relinquishing U.S. nationality, obtaining naturalization in a foreign state, taking an oath of allegiance to a foreign state, serving in the armed forces of a foreign state, engaged in hostilities against the U.S., working for a foreign government in a policymaking role, or making a formal renunciation before a U.S. diplomatic officer abroad. Two more include renouncing citizenship in writing inside the U.S. during wartime and committing treason. The critical requirement in every case is that the act must be voluntary and done with intent to give up citizenship. Every year, thousands of Americans voluntarily choose to give up their U.S. citizenship through the formal renunciation process. This is the most direct and clearest expatriating act. Relinquishment of U.S. citizenship by taking the oath of renunciation, voluntarily, and with the intent of relinquishing citizenship, is a personal right that cannot be exercised on a person's behalf. A parent cannot renounce on behalf of a child. The process requires 2 interviews with a U.S. consular officer abroad, the signing of official State Department forms, and payment of a non-refundable fee of $450. After signing the oath in front of a consular officer, the application goes to the State Department for final approval, a process that can take 3 to 6 months, and once approved, it is permanent and irrevocable. One of the most serious grounds for losing U.S. citizenship, both voluntarily and through legal proceedings, is treason. Under INA Section 349A(7), a U.S. citizen who is convicted of committing an act of treason against the government of the United States, or for attempting by force to overthrow or bear arms against the United States, can lose their citizenship as a result. This is one of the few grounds that applies to both native-born and naturalized citizens alike. Historically, this provision has been invoked extremely rarely, reserved for the most extreme cases of betrayal of the nation. In modern application, this ground has also been interpreted broadly to include those convicted under federal statutes related to seditious conspiracy and bearing arms against the government in armed insurrection scenarios. Here's one of the most common questions people ask. Can someone born in the United States have their citizenship taken away? The short answer is no, not through denaturalization. The 14th Amendment guarantees citizenship to all persons born on U.S. soil. The Supreme Court has consistently upheld this protection. Denaturalization under federal law applies only to those who obtained citizenship through the naturalization process, that is, immigrants who applied for and were granted citizenship. However, birthright citizens can voluntarily lose their citizenship by committing one of the 7 expatriating acts, such as pledging allegiance to a foreign government or formally renouncing. But crucially, the government cannot initiate proceedings to revoke the citizenship of a natural-born citizen. That constitutional wall has held for over a century and has not been breached. If a person is successfully denaturalized by a federal court, the consequences are severe and immediate. The individual reverts to whatever immigration status they held before becoming a citizen, typically lawful permanent resident. From that point, they become subject to deportation proceedings if they have a deportable criminal offense on their record. their U.S. passport is revoked. They lose all rights tied to citizenship, including the right to vote, to serve on juries, and to hold certain federal positions. One important legal nuance: a court has held that a person cannot be removed based on a conviction for a crime that occurred while they were a U.S. citizen, even though they were later denaturalized. However, the path from denaturalization to removal is often swift, and in many cases, deportation follows shortly after the court's ruling. If the government initiates denaturalization proceedings against you, you have legal defenses. The most powerful defense is materiality, arguing that any misstatement or omission on your application was not material to the citizenship decision. Even if a statement was incorrect, denaturalization requires materiality. The lie must have a natural tendency to influence the naturalization decision. You can also argue lack of willfulness, that the omission was a good faith mistake, a translation error, or a misunderstanding rather than deliberate fraud. And you can argue that you actually met all the statutory requirements at the time, defeating the illegal procurement claim entirely. These due process protections remain in place regardless of how many cases USCIS refers to the Justice Department. Get an immigration attorney immediately if you receive any government inquiry. Let's bring it all together. U.S. citizenship can be lost in two broad ways: through government-initiated denaturalization or through voluntary expatriating acts. Denaturalization only applies to naturalized citizens, not those born on American soil. The three legal grounds are illegal procurement, willful fraud or misrepresentation, and concealment of criminal or subversive history. The process requires a federal court ruling. The government cannot strip citizenship administratively, and under Supreme Court precedent, citizenship cannot be revoked for conduct that happens after naturalization. In 2026, the U.S. government is pursuing this process more aggressively than at any point in modern history. Whether you are a naturalized citizen, an aspiring one, or simply a concerned American, knowing your rights is your first line of defense. Like and share this video, and subscribe for more in-depth legal and policy breakdowns.